All right, I want to read you a few lines from this book so you can get a grasp of what it was like to be in their head at their time and kind of to see how dense and complicated this book is to read. It is a settled point with writers on the It is a settled point with writers on the natural law that all men inherit from nature a perfect liberty and independence, of which they cannot be deprived without their own consent. In a state, the individual citizens do not enjoy them fully and absolutely, because they have made a partial surrender of them to the sovereign. But the body of the nation, the state, remains absolutely free and independent with respect to all other men, all other nations, as long as it has not voluntarily submitted to them. That is a huge key part. Go back to the very beginning, first line. Nations or states are bodies politic, societies of men united together for the purpose of promoting their mutual safety and advantage by the joint efforts of their combined strength. Such a society has her affairs and her interests. She deliberates and takes resolutions in common, thus becoming a moral person who possesses an understanding and a will particular to herself, and is susceptible of obligations and rights. To establish a solid foundation, the obligations and rights of nations is the design of this work. The law of nations is the science which teaches the rights subsisting between nations or states and the obligations correspondent to those rights. In this treatise it will appear in that what manner states as such ought to regulate their actions. We shall examine the obligations of a people, as well as towards themselves as towards other nations. And by that means we shall discover the rights which result from those obligations. As men are subject to the laws of nature, and as their union in civil society cannot have exempted them from the obligation to observe those laws, since by that union they do not cease to be men. The entire nation, whose common will is but the result of the united wills of the citizens, remains subject to the laws of nature, and is bound to respect them in all her proceedings. And since right arises from obligation, as we have just observed, the nation possesses also the same rights which nature has conferred upon men in order to enable them to perform their duties. We must therefore apply to nations the rules of the law of nature in order to discover what their obligations are and what their rights. Consequently, the law of nations is originally only other than the law of nature applied to nations. But as the application of a rule cannot be just and reasonable unless it is made in a manner suitable to the subject, we are not to imagine that the law of nations is precisely and in every case the same as the law of nature, which the difference only of the subjects to which is applied, so as to allow our substituting nations for individuals. A state or civil society is a subject very different from individual of the human race, from which circumstance, pursuant to the law of nature itself, there result in many cases very different obligations and rights, since the same general rule applied to two subjects cannot produce exactly the same decisions when the subjects are different, and a particular rule which is perfectly just with respect to one subject is not applicable to another subject of quite a different nature, there are many cases, therefore, in which the law of nature does not decide between state and state in the same manner as it would between man and man. We must therefore know how to accommodate the application of it to different subjects, and it is the art of thus applying it with a precision founded on right reason that renders the law of nations a distinct science. Whew. If you understood that, congratulations, you're doing good.